President of India. Part 1. In this system of parliamentary democracy, President, who is indirectly elected, is also the head of the state. The executive powers of the Union government are vested in the President. The President is also the supreme commander of the armed forces. There is no constitutional bar on the number of times a person can be elected as President. The President is not a member of either House of Parliament or, for that matter, a state legislature. The term of the office is 5 years, though there are provisions that it can be terminated in between. President can be terminated on 4 infra-mentioned grounds. 1. By resignation in writing to the Vice President of India. 2. By impeachment for violation of the Constitution. 3. By death, and 4. Invalidation of President's election by the Supreme Court of India. What qualifications are required for the office of the President of India? In order to be qualified for election as the President of India, a person must A. Be a citizen of India. B. Have completed the age of 35 years. C. Be qualified for election as a member of the House of the People, and D. Must not hold an office of profit under the Government of India or the government of any state, or under any local or other authority subject to the control of any of the said governments. Article 58. But a sitting President, or Vice President of the Union, or the Governor of any state, or a Minister either for the Union, or for any state is not disqualified for election as President. Article 58. Election of the President. The President is elected by an electoral college consisting of elected members of both Houses of Parliament and the state legislative assemblies. In this provision, the term state includes the National Capital Territory of Delhi and the Union Territory of Pondicherry. Indirect election is resorted to because President is supposed to be a nominal titular head of the state acting on the advice of Council of Ministers headed by the Prime Minister. Members of the state legislative councils are excluded from participating in President's election. In the Electoral College, each member has one vote, though the value of each vote is different from one state to the other. Likewise, the value of vote of the members of Parliament also differs from the value of vote of the members of a legislative assembly. The election does take account of the fact that states have their uniform representation and parity is maintained between the Union and the states. This is also culminated into the fact that federal ethos is further strengthened. Why indirect election of President was supported by the framers of Indian Constitution. Indirect election of President gives recognition to the status of the states in the federal system. The system of indirect election was criticized by some as falling short of the democratic ideal underlying universal franchise. But indirect election of President was supported by the framers of the Constitution the following grounds. Direct election by an electorate of some 1 billion of people would mean a tremendous loss of time, energy and money. Under the system of responsible government introduced by the Constitution, real power would vest in the ministry. So, it would be anomalous to elect the President directly by the people without giving him real powers. Term of office of President. The President's term of office is 5 years from the date on which he enters upon his office. But he is eligible for re-election. Articles 56-57. The President may resign his office by writing under his hand addressed to the Vice President of India. He can also be removed from his office for violation of the Constitution by the process of impeachment. Article 56. The only ground for impeachment specified in Article 61(1) is violation of the Constitution. Procedure for impeachment of the President. An impeachment is a quasi-judicial procedure in Parliament. Either house may prefer the charge of violation of the Constitution before the other house, which shall then either investigate the charge itself or cause the charge to be investigated. But the charge cannot be preferred by a house unless a resolution containing the proposal is moved after a 14 days notice in writing, signed by not less than 1/4 of the total number of members of that House, and the resolution is then passed by majority of not less than 2/3 of the total membership of the House. The President shall have a right to appear and to be represented at such investigation. If, as a result of the investigation, a resolution is passed by not less than 2/3 of the total membership of the House, before which the charge has been preferred, declaring that the charge has been sustained, such resolution shall have the effect of removing the President from his office, with effect from the date on which such resolution is passed. Article 61. Since the Constitution provides the mode and ground for removing the President, he cannot remove otherwise than by impeachment in accordance with the terms of Articles 56 and 61. Conditions of President's office. The President shall not be a member of either House of Parliament or of a House of the Legislature of any state. And if a member of either House of Parliament or a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as President, shall not hold any other office of profit. Article 59. 1. Powers and functions of the President. The Constitution says that the executive power of the Union shall be vested in the President. Article 53. The President of India shall thus be the head of the executive power of the Union. It may be said that the powers of the President will be the powers of his ministers, in the same manner as the prerogatives of the English Crown have become the privileges of the people. Dicey. An inquiry into the powers of the Union government, therefore, presupposes an inquiry into the provision of the Constitution which vest powers and functions in the President. Executive powers of President. The executive power of the Union is vested in the President. The executive power does not only mean the execution of laws passed by the legislative but also the powers to carry on the business of the government. However, it is evident that President is not free to use his powers, rather he acts, binding, on the advices of the Council of Ministers. In this regard, the 42nd Amendment is a milestone. The 44th Amendment, however, did loosen the grip to some extent, as it gave the President of India the right to return a bill for reconsideration of the Cabinet and is bound to give his consent when returned. Administratively, the President may not discharge any function as there are ministries responsible for such an act. This way President becomes a formal head and action is taken in his name. All contacts and assurance of proper made on and executed in such manner as the President may direct or authorize. Article 299. Again, though he may not be the real head of the administration, all officers of the Union shall be his subordinate. Article 53(1). and he shall have a right to be informed of the affairs of the Union. Article 78b. The administrative power also includes the power to appoint and remove the high dignitaries of the state. Under Indian Constitution, the President shall have the power to appoint the Prime Minister of India, other ministers of the Union, the Attorney General for India, the Controller and Auditor General of India, the judges of the Supreme Court, the judges of the High Courts of the states, the Governor of a state, a commission to investigate interference with water supplies, the Finance Commission, the Union Public Service Commission and joint commissions for a group of states, the Chief Election Commissioner and other members of the Election Commission, a special officer for the scheduled castes and tribes, a commission to report on the administration of scheduled areas, a commission to investigate into the condition of backward classes, a commission on official language, special officer for linguistic minorities. In appointing the judges of the Supreme Court, the President shall consult the Chief Justice, as he may deem necessary. Article 124(2). These conditions will be referred to in the proper places, in connection with the different offices. The President shall also have the power to remove his ministers, individually, the Attorney General for India, the Governor of a state, the Chairman or a member of the Public Service Commission of the Union or of a state, on the report of the Supreme Court, a judge of the Supreme Court or of a High Court or the Election Commissioner, on an address of Parliament. Legislative powers of President. In India, President is both executive head and also the part of legislature. The President has power to summon and prorogue Parliament. He can also dissolve the Lok Sabha before the expiry of 5-year term. The President also enjoys the power to summon a joint sitting of both House of Parliament in case of difference between the two. The President also addresses the opening session of a newly elected Parliament. He can also address it jointly in between. The President also enjoys the power to nominate certain members of the Parliament. In Rajya Sabha 12 members are nominated and 2 members from Anglo-Indian communities are nominated to the Lok Sabha. If the community has not been adequately represented in his opinion in the House. Legislative powers of the Indian President may be summarized as follows. A. Summoning, prorogation, dissolution. Like the English Crown, our President shall have the power to summon or prorogue the Houses of Parliament and to dissolve the lower house. Them. Arts. 85, 108. B. The opening address. The President shall address both Houses of Parliament assembled together at the first session after each general election to the House of the People and at the commencement of the first session of each year, and inform Parliament of the causes of its summons. Article 87. C. The right to address and to send messages. Besides the right to address a joint sitting of both houses at the commencement of the first session, the President shall also have the right to address either house or their joint sitting, at any time, and to require the attendance of members for this purpose. Article 86(1). This right is no doubt borrowed from the English Constitution, but there it is not exercised by the Crown except on ceremonial occasions. Apart from the right to address, The Indian President shall have the right to send messages to either House of Parliament either in regard to any pending bill or to any other matter, and the House must then consider the message with all convenient dispatch. Article 86(2). D. Nominating members to the Houses. Though the main composition of the two Houses of Parliament is elective, either direct or indirect, the President has been given the power to nominate certain members to both the Houses. In the Council of States, 12 members are to be nominated by the President from persons having special knowledge or practical experience of literature, science, art and social service. Article 81. The President is also empowered to nominate not more than 2 members to the House of the People from the Anglo-Indian community, if he is of opinion that the Anglo-Indian community is not adequately represented in that House. Article 331. E. Laying reports, etc., before Parliament. The President is brought into contact with Parliament also through his power and study to cause certain reports and statements to be laid before Parliament, so that Parliament may have the opportunity of taking action upon them. G. Assent to legislation and veto. Veto over Union legislation. A bill will not be an act of the Indian Parliament unless and until it receives the assent of the President. When a bill is presented to the President, after its passage in both Houses of Parliament, the President shall be entitled to take any of the following 3 steps. He may declare his assent to the bill, or he may declare that he withholds his assent to the bill, or he may, in the case of bills other than money bills, return the bill for reconsideration of the Houses, with or without a message suggesting amendments. A money bill cannot be returned for reconsideration. In case of 3. If the bill is passed again by both Houses of Parliament with or without amendment and again presented to the President, it would be obligatory upon him to declare his assent to it. Article 111.